Good evening, ladies and gentlemen. Good evening, good evening, good evening. I'm your host, Kiana Canada. Welcome to the Kiana Canada Show. Before we get into today's topic, don't forget to like, share, and subscribe to this YouTube podcast and this channel. Remember that your likes, your shares, what it does is it pushes videos like this up in the algorithm. It tells the algorithm that these videos are important. But we must be reminded that just because videos like this are not pushed up in the algorithm, that is not an indication that these videos are not important. Before we get into today's topic, I am just going to cream my hands because they feel very dry for some reason. It's like, when you wash your hands all the time, like in the bathroom, and without putting lotion on them, they get very dry. So that's what's happening right now. So I'm going to give an announcement. It's an announcement that I give all the time in my podcasts and in my YouTube videos. It has to do with transnational repression. Now, before I give this announcement that I always give, we need to be reminded that transnational repression is essentially that. It's not anything else. Now, I understand that in the Republic of Ireland, in the United States of America, and in Northern Ireland, they are calling transnational repression by another name or equipping it with a different, uh, equipping it as a different phenomenon. But we need to be reminded that transnational repression is essentially that. It is where countries are seeking to silence the dissent of a citizen or a foreign national. Now, the dissent does not necessarily need to be um, the dissent that is being silenced is does not necessarily need to be the dissent of the the state's citizen. It can be a foreign nationals whose dissent is being silenced. And states are coming up with very unique ways to silence dissent of their citizens and of foreign nationals as well. So the transnational repression literature specifically names like six typologies of transnational repression, and that is threats, digital surveillance, uh, in some of the most extreme cases, unalivement. And if we peel back some of the layers of these more hard tactics, we can come to see that there is extraordinary renditions, incommunicado detention, enforced disappearances. But there are some soft tactics that states in the global north will use to attempt to silence the dissent of a foreign national or its citizens. And this is because there is a larger stake at issue with reputation. And if we are to be honest, ladies and gentlemen, I think that everyone in the world knows that most countries participate or partake in transnational repression. It's not a big secret. So the fact that states are attempting to call it something completely different is beyond me. But it's like the coming out of the closet moment. For example, every when a person is uh, gay or something, right? Uh, and everybody knows, right? So the question is like, why doesn't that person come out of the closet? And there are some implications there, right? Well, the person may want to come out on their own volition, which is, of course, their right to do so. No one can't force that person to do that. It's the same thing with transnational repression. I think that the global north states are in denial about transnational repression and their participation and their role in it. And so it's going to take them quite some time to actually go ahead and come out of the closet with uh, the fact that they are engaging in this practice and that they do believe in it and that they do support it and that they do like it and will come to understand that no one is finds it to be surprising at all, like everybody knows. But we all everyone who is cognizant of it, you can't keep us in denial about it because we already know. And so I just think that that's just an interesting tidbit to mention. We're going to continue our discussion on entrapment. Now, ladies and gentlemen, in our last video, we were talking about entrapment and we were talking about where law enforcement authorities, such as intelligence agencies, will seek to entrap a person. And if you remember in that video, what I did was I actually analyzed the case law and synthesized it and really tied it to when we are thinking about it, right? I actually tied it to instances where intelligence agencies, either through their, you know, or excuse me, state agents or governments through their intelligence agencies or through the work of members with IT skills, how they will actually attempt to, I guess, cajole and manipulate a person into committing an act against national security. And so before we get into this next case, ladies and gentlemen, the question is, why should we all be concerned about this? Why should universities be concerned about this? Why should human rights organizations be concerned about this? Why should we all be concerned about this? And I'm going to be honest with you, I did not do a lot of preparation for this video. It's not really extemporaneous because I did look up some cases on this topic, but it's important to know that my reasoning is just going to be kind of, I guess, impromptu, and I'm thinking about this as we go along. So, in my personal opinion, ladies and gentlemen, I think that states um, that are not participating in transnational repression, human rights organizations, universities, lawyers, solicitors, etc., the United Nations, etc., that all these entities should be worried about state agents who are seeking to push a person into an act against national security. And the reason why we should be concerned about that is because it puts us all in jeopardy. It puts us all in danger, right? And the purpose of intelligence agencies is to collect evidence or collect information. Basically, intelligence agencies are information gathering uh, excuse me, not organisms, mechanisms, or through their mechanisms, through their organization, through their apparatuses, they actually gather information. And without, of course, the public and institutions, uh, people like you and I, and people outside of you and I, these intelligence agencies wouldn't really uh, be effective, right? And so, when gathering information, i- in my personal opinion, I think that intelligence agencies, what they should do is that they should examine this information and then consider whether or not that information poses a legitimate threat to national security. And if that information does, then the intelligence agency should be more concerned with that information and the person who is creating that information or putting that information into circulation. But is there a fine line between what the intelligence agency perceives as a threat to national security and what really is a threat to national security? So, for example, if a person is very passionate about a subject and they're speaking about a subject online, like, is there a way to determine whether or not that speech is protected speech or whether that speech is in violation of the law? And that would be another conversation for a different day. That's more so an Article 10 violation. And so I might get into the discussion about foreign nationals and foreign countries and how their speech may be protected and how it might not be protected. But again, that's a conversation for another day. But what I really want to focus on in this particular segment, ladies and gentlemen, is the incitement of intelligence agencies. So, as a recap, in the last video, we visited a number of cases where the case law said that in instances where an intelligence agency is actively participating in the not as a passive investigator, but as an active uh, manipulator in these offenses, then that would be perceived as entrapment. Now we understand that in the jurisdiction in the United Kingdom, the case law or the rules are broader than in other jurisdictions. So in the United Kingdom, that there is a likelihood that evidence of entrapment will be, or excuse me, not evidence of entrapment, but the fruit of the poisonous tree would be admitted into evidence. So, what is fruit of the poisonous tree? Fruit of the poisonous tree is any evidence that is illegal. So, for example, when a intelligence agency or police department taps a phone without a warrant, and then they use that information to possibly incriminate a person, and then use that information in trial. Well, because of the unclean hands that information came from. So, for example, that wasn't through the proper process, right? There's a process of obtaining a warrant and then getting information and then submitting that information in court. And so, because this evidence didn't go through the proper procedures, then that evidence is likely to be eliminated and not admitted in court. Before we move further, I need to really give you a disclaimer that this is not legal advice. This is just um, informational purposes only, and talking about entrapment and tying that into transnational repression. And so, if you are dealing with a case of entrapment or transnational repression, and you believe that authority figures are attempting to entrap you, it's important for you to actually seek out legal advice and contact a solicitor or lawyer. Now that that's been said, so going back to the fruit of the poisonous tree, let's say, for instance, an intelligence agency seeks to try and convict you, and they have no evidence. And so what they do is they plant evidence in your room that can be considered fruit of the poisonous tree as well, because again, that evidence is illegitimate. It's not real. It may be tangible, but that evidence does not belong to you. So we and now that I'm thinking about that, ladies and gentlemen, we may actually deal with the fruit of the poisonous tree in another video. Now, I understand that the fruit of the poisonous tree is phraseology that is used in the United States, and I'm not quite sure that that is used here in the United Kingdom or Europe, but I will find out. Okay, so let's go ahead and get into our case. Our case today, ladies and gentlemen, is Furcht versus Germany. And oftentimes, when we're looking at entrapment cases, I've noticed a trend that entrapment cases have often dealt with situations where there is, for example, a person and the police agents are looking to entrap them for selling like narcotics or drugs. And there seems to be a trend of that. And so there's a lot of case law on that. And that's going to be like a case that we are going to be talking about today, where there was like 5 undercover police officers and they suspected that a group of people were selling narcotics. And then what happened was that um, they began tapping that person's phone and surveilling this group of people. And I think eventually, ladies and gentlemen, what happened was that the there was like an undercover police officer that came into the situation and attempted to persuade and cajole a person into either selling something or committing an act of something. But let's go back into the case because I didn't read the entire thing. And so it says the applicant subsequently established contacts between the 2 undercover agents for organizing an international contraband trade in cigarettes. And after one of the undercover agents had pretended to have suitable lorry at hand for transporting the cigarettes abroad. Okay, so now we get an understanding of what this case is about, right? So it seems to be about some kind of transnational uh, trafficking of narcotics, right? And so the person refused, however, to communicate directly with the undercover agent by telephone and proposed to communicate via the applicant. When the undercover agent disclosed to the applicant on the 23rd of January 2008 that he considered that the risk of being caught with these like, and I think what was happening and that they were trying to smuggle these cigarettes into a different location, that situation was like a high probability of getting caught. The applicant disclosed that they would also take this narcotics and take it themselves, right? And so essentially what happened, ladies and gentlemen, is that so on February the 8th, so I'll go ahead and continue to read more so we don't miss out on the important details. On February the 7th, 2008, the district court, having regard for the applicant's submission to the undercover agent on the 23rd of January 2028, extended to the court authorizing the investigations to cover also the applicant. The applicant thereupon continued arranging 2 purchases. So basically, I think I think we can understand what's going on, right? Essentially, what's going on is that you had a group of people that were suspected initially of trafficking drugs. And during this period of time, the undercover agents, I guess in Germany, because that's where this case is coming out of, were cognizant of this activity or suspected that these applicants could be engaged in this activity. And so what happened was that the applicants, the police officers, the intelligence agencies decided to involve the applicant in a sting operation. I guess that's what you could call it. And so in this operation, essentially, as I'm reading this case, what I discover is that the police officers were consistently contacting the applicant, even after the applicant decided that they didn't want to take part in the sale or the transport of these narcotics. And so after the applicant, or excuse me, after the applicant said no, the police officers continued to make contact with the applicants. And then finally, I think that there was activity. There was an illegal act that took place, in which landed the applicant in prison or arrested, and then on charges of a crime. And then now the appeal went to the European Court of Human Rights. So essentially, what happened was the case went through the appeals level, and then I guess there was no redress at the domestic levels, and so it reached the international level at the European Court of Human Rights. And the European Court of Human Rights ruled on this case, and this is what we are going to be talking about today. So I'm going to share my screen, but I'm going to be looking at the reasoning of the court, and we're going to try and make sense of this when it comes to transnational repression. So let's see. Windows. Mm, I think it's here. Okay. Yes. So I'm going to make sure that we're still good on this screen. Okay, I think we're good. So I highlighted some areas that I thought was very important, and this is what we're going to be discussing today. So let me go. Okay, so this is really the court's assessment of the relevant principles, and this is what I want to go over. So, of course, I mean, there is submissions by the applicants and there's submission by the government. And those are important as well. But what I think is very important here is the relevant principles and the submissions by the court, because essentially it's the court who assesses the submissions of the not only of the applicant, but the government as well, and makes sense of it, analyzes it, and makes a decision. And so the court, at para 46, the court reiterates that the admissibility of evidence is primarily a matter for regulation by national law, and as a rule, it is for the national courts to assess the evidence before them. The court, for its part, must ascertain whether the proceedings as a whole includes the way in which evidence was taken were fair. And then there is this landmark case. I think it's a landmark case, which is Teixeira de Castro versus Portugal. And then that case again that we talked about in our last segment is Ramanuuskas versus Lithuania. And so these are two very important cases when we are talking about entrapment. And so the court went on to say that the use of undercover agents may be tolerated provided that it is subject to clear restrictions and safeguards. While the rise in organized crime undoubtedly requires the appropriate measures to be taken, the right to a fair administration of justice nevertheless holds such a prominent place that it cannot be sacrificed for the sake of expedience. The public interest in the fight against crime cannot justify the use of evidence obtained as a result of police incitement, as to do so would expose the accused to the risk of being definitively deprived of a fair trial from the outset. So you can kind of see that the court is already setting the ground that fruit of the poisonous tree, this unfair evidence, this illegal evidence that is being admitted into legal proceedings is a no. It's unacceptable. Let's continue. At para 48, when faced with a plea of police incitement or entrapment, the court will attempt to establish whether there has been such incitement or entrapment. Now, this is important, ladies and gentlemen, at 48, because the European Court of Human Rights, what it does is it distinguishes between what police incitement is and what entrapment is. So the court states that police incitement occurs where the officers involved do not confine themselves to investigating criminal activity in essentially passive manner, but exert such an influence over the subject as to incite the commission of offense that would otherwise not have been committed in order to make it possible to establish an offense, that is, to provide evidence and institute a prosecution. Now, ladies and gentlemen, it's important. This paragraph is very important. Number 48 is very important because if you remember that the same language is actually cited in the cases in the United Kingdom, in the cases in the Republic of Ireland, in Northern Ireland. So the same language about what entrapment and incitement uncannily similar. So I think what is happening is that the courts, excuse me, that the European Court of Human Rights, what it's doing is pulling from these domestic jurisdictions and I think collating these cases and making sense of it and saying, hey, this is an illegal practice and this can't happen. And so the court went on to say that the rationale behind the prohibition of police incitement is that it is the police's task to prevent and investigate crime and not to incite it. Now, ladies and gentlemen, I'm laughing because isn't that what I've been saying this entire time? Like, I've been saying, like, now we're tying this to transnational repression and national security issues. Isn't this what I've been saying the entire time? Like, it's the police's job, the intelligence agency's job to really investigate threats to national security and criminality, not to incite that, not to try and push somebody over the edge, not to try and incite a person to commit an offense that would be perceived as a threat to national security. I want to read that again because I think it's important. The rationale behind the prohibitions, so the prohibition of incitement and entrapment on police incitement is that it is the police's task to prevent and investigate crime and not incite crime. Now, ladies and gentlemen, a question that we need to raise is how can police investigate crime and prevent crime if they're busy inciting it, if they're busy trying to make it happen? I want you to think about that for a moment before we move on. I'll ask again, how is law enforcement preventing and properly investigating crime if they are actively engaged in trying to incite it? That's something for you to answer. I already have my answer. I already know the answer to that, which I've been speaking about at length on this channel. But I want to continue with the court's reasoning because I think it's very pertinent to what we're talking about. So, in order to distinguish police incitement or entrapment in breach of Article 6, paragraph 1, from the use of legitimate undercover techniques in criminal investigations, the court has developed the following criteria. And, ladies and gentlemen, this is very important. And I think that this is very important if we are seeking to ask ourselves, such as human rights organizations here in Northern Ireland or across the European Union, to ask yourselves whether or not these intelligence agencies are doing the right thing and whether or not these human rights organizations are standing on the right side of justice. So we need to look at the court, the European Court of Human Rights, because of course they are experts in analyzing these kinds of cases and they really study these issues all the time. So we should really consider their expertise and their reasoning. And so let's go with their criteria here. They said in deciding whether the investigation was essentially passive, the court will examine the reasons underlying the covert operation and the conduct of the authorities carrying it out. The court will rely on whether there were objective suspicions that the applicant had been involved in criminal activity or was predisposed to commit an offense. Okay, so the court has found in that context, in particular, that the national authorities had no good reason to suspect a person of prior involvement in this particular offense, where he had no criminal record, no preliminary investigations, and had been and had been open against him, and that there was nothing to suggest that he had a predisposition to come involved in dealing with like these narcotics until he was approached by police. Okay, so ladies and gentlemen, in this particular section here, the court is saying, okay, well, if a person is doesn't have a criminal history, or there's no preliminary investigation, and then there's no predisposition to create to commit an offense, well, then that's the first step. And we must be reminded that other jurisdictions, such as the United States, has further stated that just because a person does have a criminal history, because they are a pariah in their community, that is not even evidence that the person, or not evidence, but that is not rationale or justification that that person should be entrapped. So let's continue. And so, in addition to the aforementioned, so this is, the first criteria, right? And so, in addition, the following may, depending on the circumstances of a particular case, also be considered indicative of pre-existing criminal activity or intent. The applicant demonstrated familiarity with the current prices for drugs and ability to obtain drugs at short notice, and the applicant's pecuniary gain from the transaction. So here the court is saying, okay, well, maybe this is something that could be taken into consideration. But is it probative? Is the question? Is it probative, or is this probative value? I think unfairly. Does it outweigh the purpose of, I guess, this what this evidence seeks to accomplish, right, at a trial, if this goes to trial? And obviously, it seems like it did. And so, again, the question is, even is that information probative? At paragraph 52, the court said, when drawing the line between legitimate infiltration by an undercover agent and incitement of a crime, the court will further examine the question whether the applicant was subjected to pressure to commit the offense. In drug cases, it is found that abandonment of passive attitude by the investigating authorities to be associated with such conduct as taking the initiative in contacting the applicant, renewing the offer despite his initial refusal, insisting, prompting, raising the price beyond average. So, ladies and gentlemen, we actually read this particular passage before. And again, we understand what pressure is, right? Pressure is where to reiterate, is where there is direct contact of some sort with the applicant. Now, you may say, well, Kiana, well, how is the how is there direct contact with the applicant in transnational cases? Well, ladies and gentlemen, when there is an intelligence agency that is actively harassing you online, of course, we understand that it wouldn't be anyone else but an intelligence agency, or by proxy, using uh, individuals with intellectual, or excuse me, IT capabilities, right? So information technology skills. We come to understand, ladies and gentlemen, that this is not passive, this is active, right? It's active because there is a person that is presently involved, that is intimidating you and trying to get you to uh, respond with anger. And let's even take it further. Let's say, for instance, that an intelligence agency contracts or collaborates with a confidential informant, and this confidential informant is in the public, and they're trying to get you to respond to uh, their provocation by provoking you, by calling you names and trying to get you to respond with violence so that you can attack them. And then these intelligence agencies can swoop in and then arrest you. Well, that is not passive because what is passive is where there is no uh, active involvement in, for example, let's say, for instance, you decide that you want to attack somebody on your own. Well, you did that on your own violation. There was no provocation. Nobody was actually provoking you to do that. And so, therefore, the intelligence agencies would have a legitimate reason to arrest you. But it's not legitimate to arrest you when they're actually inserting a person into your life and trying to get you to react to that person. That is provocation. And you may say, well, Kiana, well, can you prove that that person was uh, involved, or that they had communication with uh, an intelligence agency? And so, again, the burden of proof, and we're going to read that because I think that they said something about that in this case, but I've been saying that the entire time, is that the burden of proof is really not on the applicant to establish that there was this provocation, or that, for example, that this confidential informant was connected to the intelligence agency. All they need to do is make out a prima facie case that this is possible and that this is probable. And once they make out a prima facie case, the burden of proof then shifts back to the government to essentially make their case as to why that may or may not be so. So let's go ahead and continue. So when applying, we're at paragraph 53, when applying the above criteria, the courts places the burden of proof on the authorities. So see here, here what I just said. It falls on the prosecution to prove that there was no incitement, provided that the defendant's allegations are not wholly improbable. So, for example, ladies and gentlemen, a lot of the times what I hear from people, especially like people that are not educated in the law, and that doesn't mean that like I know a lot about the law. I mean, I took law in undergrad, studied the law on my own, you know, as an autodidact, and then I'm doing a master's in international human rights law. And a lot of the law that I'm actually taking in is really not from the program, but really, again, through my own autodidacticism. But what I often hear, ladies and gentlemen, is that uh, people that have no familiarity with the law would often say, well, where is the evidence? We need evidence. We need, and they don't understand how this works. It's like testimony is evidence. I mean, we see it all the time. Like when you look, of course, it's not direct evidence, but in some cases, it can be used as circumstantial evidence. But testimony is evidence on its own. And so when people say, well, where is the evidence? We need to see direct evidence that this person, that intelligence agencies are involved, or that intelligence agencies are doing A, B, C, and D. They're completely wrong. Again, let's reference the European Court of Human Rights, because these are experts who deal with these kinds of cases all the time. They're human rights experts. They sit on the bench and they review these cases all the time. And so I think their analysis and that their uh, opinion of the matter is more important than, and carries more weight than an intelligence agency looking to get out of a case, looking not to be tied to a case at the European Court of Human Rights, or some random person who uh, just is really not well versed in law. So again, let's defer to this, and let's read number 53. Let's continue. So when applying the above criteria, the court places the burden of proof on the authorities. It falls to the prosecution to prove that there was no incitement, provided that the defendant's allegations are not wholly improbable. So, what does that mean, ladies and gentlemen? So, it's the defendant who essentially makes out a prima facie case and says, hey, well, this authority had actually entrapped me, or this authority, there was a confidential informant who was involved, or there was an intelligence agency that was involved, and they tried to persuade me or cajole me into committing an offense. Again, that's the reasoning that the court has given here, provided that the defendant's allegations are not wholly improbable. And that's not improbable because okay, how do we determine whether something is probable or improbable? Well, we determine it by asking ourselves this following question. Well, is it probable that an intelligence agency or a police department would seek to entrap an applicant? And if the answer is yes, then the burden of proof shifts to the government. Because, again, we're reading a case of entrapment, and the case is actually citing multiple cases that deal with entrapment. So this has actually happened before. So it is probable that the government would engage in this kind of conduct. Let's continue. In practice, the authorities may be prevented from discharging this burden by the absence of formal authorization and supervision of the undercover operation. Okay, we understand what that means. The court has emphasized in the context the need for a clear and foreseeable procedure for authorizing investigative measures, as well as for their proper supervision. It is considered judicial supervision as, excuse me, it considered judicial supervision as the most appropriate means in case of covert operations. Okay, so ladies and gentlemen, this is where the chess move all often works in the applicant's favor. One, if there is judicial supervision, so for example, if a court authorized this procedure. So, for example, the court said, okay, yes, you can surveil that person. Yes, you can investigate that person. And the authorities are not taking a passive role, but they're actually taking an active role in trying to incite the person into committing an offense. Well, now we have um, something to fall back on because we know that this was authorized by authorities. And now we have to look to that police agent's conduct. So again, that doesn't go against the applicant, I don't think, because, for example, we have that, in my personal opinion, what that does is that satisfies that, provided that the defendant's allegations are that are not wholly improbable. So if the defendant states that they believe that they have been entrapped, and then the court looks to see if there was a warrant in place, and they find that there was a warrant that was authorized by the court, then we can see that I guess that line of thought from the defendant is correct, because by virtue that there is a warrant in place. Now, what if there's not a warrant in place? Well, they're in court, right? And there must be probably not an authorization there. The court didn't authorize it. The supervisors didn't authorize it. So this must be done by police officers or intelligence agencies who are seeking just to harass and intimidate a person, which is illegal. And so you can kind of see that in both these scenarios, that they work to the applicant's benefit if the agents are really trying to incite the person and harass the person into committing an act against uh, committing an act that violates the law, instead of actually passively investigating what they believe to be a crime. Let's go ahead and continue. There's just one more paragraph that I want to read that I think is very interesting. So, as the government's argument that the applicant was nevertheless predisposed to commit a criminal offense because he had himself raised the possibility to deliver drugs, had proposed the quantities of the drugs to be delivered, and had described himself as part of a group with S, and had been able to initiate the deal quickly via his contacts. So basically, the government is saying this person was predisposed to commit a crime because look at their activity and look at their involvement. But this is what the court says: the relevant time for determining whether there was objective suspicions that the person concerned was predisposed to commit a criminal offense is the time when the person was first approached by the police. So remember, in my last video, we were talking about how there is case law that is saying that we need to consider the applicant where you first found them. And it's the same thing in this particular situation. Well, when the authorities made contact with the applicant, did the applicant say that they wished to commit an act against national security? Did the applicant say that they wanted to commit an illegal act? And if the answer is no, ladies and gentlemen, so that is where these intelligence agencies and these, because remember, we are actually tying this to intelligence agencies and police departments who are abusing their intellectual apparatuses. So if at the first time that these intelligence agencies or these police officers encounter the applicant or the person that they are suspecting of possibly engaging in maybe a criminal act, because ladies and gentlemen, let's be honest, a lot of the times people who are set up by intelligence agencies and police departments, they do encounter police officers, undercover agents, but never know who they are, right? And I'm pretty sure, like in all of our lives, like we've encountered an intelligence officer or an undercover agent, really not knowing who they were, just thinking that they were an ordinary person engaging in discussion with them that was really benign. And so again, going back to the issue, right? Going back to what's very important here, at that initial contact between the applicant and this person that is working undercover, if the applicant never demonstrated a propensity to engage in an act against national security or any kind of criminality in those discussions, then this actually works in that applicant's favor, because the more time that passes by, so whether that's 6 months, 9 months, 12 months, 2 years, etc., right? The more time that passes by and the applicant doesn't do anything, and law enforcement continue to try and push that person into committing an illegal act, that is more evidence of incitement. To be sure, let's go back to what the court said. The relevant time for determining whether there was objective suspicions that the person concerned was predisposed to commit a criminal offense is the time when the person was first approached by the police. As found above, when the undercover officer started contacting and meeting the applicant in November 2007. So, ladies and gentlemen, you can see like this had taken place for quite some time, because this was in November 2007. And then I think that the arrest was in 2008. So there was like several months there. And we know that these kinds of predatory investigations can go on longer than a year, 2 years. The investigation authorities, as clearly established by the regional court in its judgment, did not consider that the applicant was predisposed to traffic. So the court initially didn't think that the applicant was predisposed to engage in criminality, as based on the assumption of such a predisposition. All the more, the applicant had already explained at the moment not to be interested in any business or other than the restaurant he ran. So, again, initially the applicant was saying, "Hey, I'm just interested in legal business, like my restaurant." But then you have an undercover agent that is saying, "Okay, well, what about this?" And then they have attached themselves to this person like parasites in a continuation to try and provoke and persuade what they did in this case. According to the applicant, the important information had not even been communicated to this district court by the prosecution. In these circumstances, the elements mentioned by the government cannot serve to prove that it was reasonable to conclude that the applicant was predisposed to trade in narcotics. So essentially, ladies and gentlemen, what happened in this particular case, how the court essentially ruled that there had been a violation of Article 6, Paragraph 1 of the Convention, and that the police agents, the government was wrong in this particular case. So, what does this tell us? Like, what do these cases teach us? Because, ladies and gentlemen, this is one case, right? And then we have domestic case law that I read from the United Kingdom. And then we had other precedents from the European Court of Human Rights. And there's a consistency in these case law. There is a consensus at the domestic level and even at the international level that this kind of conduct is illegal. So why don't human rights organizations take on these kind of cases is the question. This is actually a layup for them, isn't it? For example, it's not one of those when you think about it, like it's not where the agency needs to try and make it at the 3-point line, right? No, this is a layup. Like you're close to the goal because the case law is saying that this kind of conduct is illegal. So why is the human rights organizations not taking the layup? And why are they not even attempting to take the 3-point basket? I mean, if not the layup, then why not the 3-point basket? I mean, this is their game. I mean, it's not like we're not playing their game, right? This is their game. Like this is what they're supposed to, the kind of cases that they're supposed to be taking. This is not like outside the realm of a human rights organization. I mean, as you can see, this case went to the European Court of Human Rights, Article 6 violation. And yes, in our last segment, we discussed how there was a case that, and I'm pretty sure there's more if I look into it. I might have to look into it. I just might have to like do some more research where this is an Article 8 violation. So, ladies and gentlemen, it raises an important question, doesn't it? As to why. And it raises, not only does it raise an important question, but it also puts things into perspective that these intelligence agencies, even if it's not an intelligence agency, right? So let's say, for example, we don't believe it's an intelligence agency. We think that it may be just uh, persons with their IT skills engaging in this kind of conduct, if that's the argument that one seeks to put forth. Well, the police have an obligation to investigate. And it still would be incitement because, again, the whole purpose of these people with IT skills is to push a person into an act against national security so that person can be arrested. It's almost like swatting, right? Like you're sending law enforcement to a person's house so that they can be unalived. It seems like a form of swatting, but a consistent basis, right? So, as we have seen, ladies and gentlemen, that the law says that this is illegal. Entrapment is illegal. Now, again, in this particular video, we are talking about specific cases that often involve drug offenses, because there is a consistency where law enforcement officers think that they can get away with entrapping people. Obviously, they've done it before. They've engaged in these kind of this illegal conduct before, and so. Uh, they may think that it's easy to do it, and so they engage in it, and then they entrap a person, and then that person is arrested and charges are brought against them, and then they are imprisoned. But what's disconcerting about this entire subject, ladies and gentlemen, is what if the person, like in some of these cases, they're not looking to commit an offense, and you have intelligence agencies and law enforcement officers that are trying to provoke the person into committing an offense against national security because they are a journalist, or because they're an activist, or because they're a human rights defender, or because they're an academic researching a human rights violation that the state wants to keep secret. It raises the question, doesn't it? Where are the advocates of human rights to say that this practice is illegal? And ladies and gentlemen, what I think often happens in these cases is that everyone thinks that it will never happen to them. And so they remain silent, thinking that if these intelligence agencies just take down this problem person who they perceive to be a problem person, if this intelligence agency just you know uh, condemns and get rid of this problem person, that everything will be all right. And we know that's really not the case. What will happen is that these intelligence agencies will see that this is precedent, and they will do it to more and more and more people. And again, it falls harder on people who are researching human rights. But again, let's be honest, a lot of people that are teaching human rights and even researching it, they really don't believe in it. That's not to say that all people don't believe in it, but there is evidence to show that many people who actually teach about human rights law and maybe research it, investigate it, they really don't care about it. They really don't believe in it. And so, of course, they're not going to be concerned about a significant human rights violation. But for the people that do care, for the academics that do care about human rights, for the students that are researching human rights violations and that they do care. For example, here on this campus, I talked to a lot of people that go out and protest for different groups, and I can really see the passion in their eyes, and I can see that they really do care. And I know that they are really attached to those issues, right? And you can see the passion in their eyes behind it. And then you can see where there are some people who really don't care, but they are just in it for, like, financial gain, or it's just a job to them. They come to work every day, and then they it's just like getting through the day. It's the motions of it all. Like, it's something that they it's a subject that they took probably when they were in university, didn't think anything about it. It was, on the roster, decided to do it, and hey, they went into it and it became a job for them. It became a career, and not that they really care about it. And for some students, that's not to say all, ladies and gentlemen, because again, to reiterate, there are some students who really care about human rights concerns. I talk to them every day and I can see the passion and I can hear, excuse me, yeah, I can see the enthusiasm and I can hear the passion in their voice when they're talking about specific issues. And so the question is, what about those people who really do care? What happens when these intelligence agencies come after them? And this is not, fear mongering. This is not an incitement to uh, violence, nor is this an incitement to attack anyone. This is for reflection purposes. And while we're reflecting on this, I want to ask the question: what happens when intelligence agencies decide that they're through with a particular person? Let's say, for instance, they're through with persona non grata A, or they're through with pariah B, and they decide we're bored with that person. If they ever do get bored with that person, we're bored with that person. We don't want to deal with that person anymore. Let's do it to this person. Then what? You see, what we see in the United States and what we see, of course, in the United Kingdom and, of course, in Northern Ireland, it's more suppressed in Northern Ireland because this is like a micro jurisdiction. So y- it's like everybody knows everyone here in this jurisdiction, and so you can't go to RTE or the Belfast Telegraph because everyone knows each other. And a lot of these intelligence agencies and police departments have a lot of influence, and so they're going to persuade these broadcasting stations not to report on this kind of conduct because, of course, uh, then everybody would really know about it and they would possibly have to stop. And these broadcasting stations are not going to report on it because they get a lot of their information from these intelligence agencies and these police departments. So whenever you look at a news story, this is homework for you. When you look at a news story, look to see where the broadcasting station, say, for instance, RTE and the Belfast Telegraph, are getting their sources from. And I want you to compile a list. So, for example, if you read RTE and there's like 20, 30 stories coming out of that broadcasting station, see how many times they're citing a source. And then that is going to tell you possibly how much influence that source has over that broadcasting station. It's something to think about. It's good homework, I think, for someone to take on. And there you have it, ladies and gentlemen. What do you think? Do you think that these intelligence agencies will ever stop harassing activists, journalists, human rights defenders, academics, and start investigating real crime? Do you think that because there has been some instances where there has been threats to national security, that this has been because intelligence agencies and these police departments, their attention is elsewhere on people like you and I, is the question. People like you and I, we don't have celebrity, we don't have status. We're just ordinary people just trying to make our mark on the world and do something positive and to just make an impact through our research and our activism or putting out the knowledge that we learn out into the world. And I don't think that we should be penalized for that. Definitely not by an intelligence agency or police department. And there you have it, ladies and gentlemen. Don't forget to like, share, and subscribe to this channel. Uh, your likes and your shares, they're very important. And again, what it does is it pushes videos like this up in the algorithm. I'm also going to link my Facebook account to the description of this video, and you can go ahead and follow me on Facebook. For a long time, I've only had 8 followers on my Facebook account. I am attributing that to transnational repression, that the Republic of Ireland, these Irish American intelligence agencies are shadow banning my account. They're doing so. They're doing it as well with my YouTube account and my Substack account. A lot of my articles on Substack are being pushed down. Like, for example, if I look for a specific article that I've written on Substack, I won't see it in the search results. I'll have to put quotation marks around the title, and then it'll come up, and that's letting me know that the actual article is being pushed down in the search results. So, ladies and gentlemen, uh, it would mean a lot if you subscribe to my Substack and subscribe to my YouTube channel and follow me on Facebook. And I will continue to put more information out there. Now, before I go, this information that I'm putting up, it may not be funny, it may not be entertaining, but it is going to be something that would help you in the long run if you are a person that is one day in a situation where you're speaking up for yourself and advocating for yourself. And oftentimes people are isolated, they don't have support. And this information may be useful to you if you are ever going through transnational repression. And so, with that, ladies and gentlemen, I hope that you have a good night and we will talk to you next time. Bye bye.